In a 7-2 decision on Thursday, the Supreme Court upheld a law that protects Native American families looking to foster or adopt Native children. The Indian Child Welfare Act was enacted in 1978 to address concerns that Native children were being separated from their families and often placed in non-Native homes. It faced a broad attack from some Republican-led states and non-Native families who argued that the law is based on race and is unconstitutional under the Equal Protection Clause of the 14th Amendment. Here to help us understand this ruling and its particulars is Jimmy Hoover. He's a Supreme Court reporter at the National Law Journal. Jimmy, first, why was the Indian Child Welfare Act passed in the first place, and what does it do exactly?
Well, as you said, it was passed in 1978, essentially in order to stop what Congress had identified as the continuing disintegration of Native communities through the adoption and foster process. Studies at the time showed that between a quarter and a third of Native children were being placed in adoption and foster care in other institutions, overwhelmingly non-Native ones. And so after a series of hearings, Congress passed the Indian Child Welfare Act to essentially create a number of safeguards that would govern the adoption process for Indian children so that they wouldn't overwhelmingly and unnecessarily be placed in non-Native homes.
So can you give us a sense then of the arguments on either side of this case?
Well, as you mentioned, the law was challenged in court by a group of adoptive parents and the state of Texas, along with other states. They argued that it essentially amounted to a form of unconstitutional race discrimination in violation of the Constitution's Equal Protection Clause in the 14th Amendment. They said that by placing non-Native families lower in the priority scale of the law, that they had essentially introduced a form of impermissible racial classification and that the law should be struck down. The states also argued that the law was unconstitutional because it, quote, commandeered the resources of state governments. That's basically a legal term that means they directed state governments to use their own resources to assist tribes in placing Native children with other Native families. And they said that that was an unconstitutional breach of Congress's authority.
Oh, man, I'd like to ask you about that, but we'd be here a long time. Let me ask you about Justice Gorsuch, because he wrote a concurring opinion that was even longer, I think, than the actual majority opinion. What do you make of that?
It was really a remarkable concurrence from Justice Gorsuch. He's long been known as the court's most vocal advocate for tribal sovereignty and tribal interests. But in this case, he went even a step further and delivered what was a really full-throated kind of view of the history of forced assimilation of Native children in non-Native homes. And Gorsuch said that the Indian Child Welfare Act, far from being Congress acting outside of its authority, was a valid exercise of its constitutional authority in order to stop the continued destruction of Native communities. And he references back to what were essentially kidnappings by the federal government of Native children in the late 19th century, all the way up to the heavy-handed practices of state-run and private-run adoption agencies prior to the Indian Child Welfare Act. So he was really taking the kind of full-throated defense of the tribal interests in this case, as he's often done.
And essentially arguing that tribal interests are unique in American life.
Exactly. That tribes have been recognized as being such, being distinct from the earliest days of the country's founding and even before then, and giving Congress the authority to negotiate treaties and to have broad powers when it comes to Indian affairs. And this is really where the majority of the court split off from the two dissenters, Justice Clarence Thomas and Justice Samuel Alito.
And so quickly, and I apologize, but what was the central argument of the dissenters?
The dissenters said that Congress overstepped. It waded into the area of family law and adoption law that has long been the purview of state governments. And, the court didn't actually reach the additional arguments about racial classification and whether that was a violation of the Equal Protection Clause. essentially kicking that case for another day. But the Supreme Court's majority rejected Thomas and Alito's view and said, no, Congress has this authority, even in the area of family law, to set these rules for Indian adoptions.
Fascinating. Jimmy Hoover, thank you so much for breaking that all down for us with the National Law Journal.
Thanks for having me.